Hello everyone, I am Rusha Mukherjee, a student of Srinivas Law College and interning with Lexis & Company. Today I am going to talk about the two principles in torts, the strict liability and the absolute liability. We know that each and every person has got certain rights, certain civil rights also. And it is the duties of all the other persons not to do something that will affect the rights of anyone, or to take all the measures, all the safety measures such that the rights of the persons is safeguarded. Now, all of the torts that we see is normally based on fault-based liability. That is, we are doing certain wrong, we are under fault, either we are being failing to do whatever we are supposed to do, or doing something that is affecting the rights of anybody else, and for that we have to compensate the person whose right is being disturbed by that. But there are certain places or certain laws that has provisions for no fault liability, that is, I am compensating for no fault of mine, and from there arises the two concepts of strict liability and absolute liability. The strict liability principle was introduced in 1858 in Reliance versus Fletcher case. Here, Fletcher had a mill while Reliance has a mine. Fletcher wanted to make a reservoir because a lot of power was required for his mill. Now, he had appointed various individual contractors or independent contractors and engineers for this purpose. They saw that there were some mine shafts in the property of Fletcher, but they did not pay a lot of attention to it. And due to this fact, the water reached the place of Reliance, and Reliance's mines were actually suffering a lot of damage. He had incurred a lot of losses, and he sued Fletcher to give him compensation for it. Now, Fletcher told that he did not do any wrong. The entire mistake was that of the independent contractor, and so he was not liable. But the court held that he was liable and he had to compensate for everything, for each and every loss that has been incurred by Reliance. From there arises the principle of strict liability. Now, there are basically three things. First of all, it is told that if there is a dangerous thing, by dangerous thing we mean any non-natural thing that was not there naturally, and if that escapes the property of the person and causes damage to anyone else, and it should be a prima facie liability of the person to maintain or to respect the right of the other person. Now, in the matter of this case, we have understood that the reservoir was a non-natural thing or a dangerous thing, and the defendant Fletcher had brought him to his property, the reservoir, and the reservoir's water had escaped from the property of Fletcher and caused damage to Reliance, and hence all the conditions of strict liability were being fulfilled. But the most important thing is, if the thing that has been brought to the property, the dangerous thing that has been brought to the property does not escape, then a person cannot be held under strict liability. Now, we will come to the case that the burden of proof in this case is lying on the defendant that he is not to be held under strict liability. However, we can see that there are certain safeguards for the defendant also. That is, if I have been incurring any loss due to some fault of mine, that is, in the case of ponting, that is where the horse of the petitioner's house, went to the property of the defendant and ate all the poisonous leaves and hence died. In this case, the person cannot be held under strict liability because the leaves did not go outside the premises, but the horse went there and ate the leaves. The next thing is, if it was done for the mutual benefit, then if it causes loss instead, then none of the parties can sue each other for the loss. Another is, whenever we are doing something by giving our consent, that yes, I have the consent that we are doing this, and if any loss is being incurred, I am liable for my own loss. Secondly, we can see the Nicholas versus the Marshland case, where it is told that if some incident happens, some loss happens due to an act of God or an unpredictable situation, then the person cannot be held under strict liability. Like when, due to extreme heavy rain, the artificial lake was flooded and caused loss. But in this case, the extreme rain cannot be predicted by someone, and hence the person could not be held liable under strict liability. In this instance, we are going to think of another idea, that is the act of stranger. If any loss is being done because of an act of a stranger, then anyone cannot be held liable under strict liability. But if I knew that someone is trying to cause any damage to my property, and for that anyone else's right can be affected, and if I don't take any safety measures for this, then I will be held liable for strict liability because I failed to take any necessary steps to stop him or to stop the stranger. And anything done by a statutory authority will not make anybody else liable for the loss incurred due to it. Now it comes the famous case of Gopal gas tragedy. That is the MC Mehta versus Union of India. It was the Union Carbide in Bhopal had set up plants. On 2nd December 1984, 40 tons of methyl isocyanate and many other poisonous gases were leaked, and almost 3,000 people died of it. Many other persons were also injured. Now comes the fact that the courts introduced the principle of absolute liability. That is, if any enterprise is doing something that is very dangerous or hazardous, even if it does not escape the property or the premises, it will be held under absolute liability. In this case, the escape is not at all necessary. Even if within the premises it causes loss to anyone else, then the enterprise can be sued under absolute liability. The most important thing is the difference between the strict liability and the absolute liability is absolute liability is against enterprises in India and strict liability is against individuals. In strict liability, it is important that escape must happen, but in absolute liability, escape may not happen. Now, the damage that is to be given by the enterprise is always proportional to the size of enterprise. These two principles have been very important for the concept of torts, and it introduces a new concept of no-fault liability where, though a person or an enterprise is not himself or herself directly responsible for the loss happened, but still they are held liable. This is all for today. Thank you, goodbye, see you soon, and have a nice day.